Judy, 2141. Judy, 2141. You didn't hear that, did you? Test 1, 2, test 1, 2, 3. Chair Mike, Judy, Chair Mike, Judy, test 1, 2, 3, 4.
1, 2, 1, 2. Good morning. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare a recess of the committee at any time. Before we begin today's markup, I'd like to take a moment to remember the life of our dear former colleague, Howard Coble. Howard, who was a senior member of the House Judiciary Committee until his retirement from Congress last year, passed away earlier this month. I am confident that everyone on the dais and in the audience has a fond memory of Howard's quick wit, his mastery of college mascot trivia, and his endearing sense of humor, though perhaps no memories are as vibrant and colorful as his collection of Madras sports coats. During his time in Congress and while he was chairman of the Court's Intellectual Property and Internet Subcommittee, Howard made promoting and protecting American innovation and creativity a priority. Howard was also a champion for the cause of criminal justice reform, fighting for some of the very topics that we will be addressing today. Howard was a dear friend, the perfect Southern gentleman, and one of the kindest people I have ever met. He also played tennis with me most Wednesday mornings for nearly 20 years. I'm sure that I speak for everyone on the committee when I say that he will be missed. And the Chair recognizes the gentleman from Michigan for any comments he may have on that subject as well.
Thank you, Chairman Goodlatte. I was deeply saddened to hear about the loss of our colleague, Howard Coble. As the longest-serving Republican House member in North Carolina history, he was a man of many accomplishments. Well known on Capitol Hill for his graciousness and integrity, I'm proud to call him my friend. Howard was a great legislator and always willing to work in a bipartisan manner to achieve results. On the judiciary, where I served with him for his entire time in Congress, he was a recognized leader in the intellectual property area. Throughout his long and distinguished career, he worked to update our country's copyright and patent laws through such historic legislation as the Digital Millennium Copyright Act, the Sonny Bono Copyright Extension Act, the American Inventors Protection Act, and the Madrid Protocol Implementation Act. He was also critical to the effort to modernize laws regarding the cable and satellite industries. Our colleague Howard Coble was a great public servant. I'm honored to have had the opportunity to work with him on these and other important issues over the years, and my thoughts are with his family and all who knew and loved Congressman Coble. Thank you, Mr. Chairman.
Thank you, Mr. Conyers. Pursuant to notice, I now call up
Chairman.
H.R. For what purpose does the gentlewoman from Texas seek recognition?
Strike the last word.
Gentleman is recognized.
Mr. Chairman, might I add my tribute and appreciation for Congressman Coble, who I had the opportunity to serve from the very moment that I came on this august panel. He was gracious at all times. He had an amazing love for his work and his constituents, and certainly he was a strong advocate for the protection of intellectual property, among many other issues. And so I want to offer deepest sympathy to his family and to his former constituents, and to let them know how much of a contribution he made as an American, both on the House Judiciary Committee in the spirit of justice, but also in the representation of his district. And I hope that he will rest in peace. I yield back, Mr. Chairman.
Chair thanks the gentlewoman. Pursuant to notice, I now call up H.R. 3713 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3713 to reform sentencing laws and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. The legislation the committee will consider today is the culmination of 3 years of work on overcriminalization and criminal justice reform. In the 113th Congress, I, along with Ranking Member Conyers, established an overcriminalization task force, which held 9 hearings on a variety of topics, including overcriminalization, over-federalization, sentencing reform, prison reform, and regulatory crime. Building upon the work of the task force, the Ranking Member and I launched a criminal justice reform initiative in June of this year. The first step in this initiative was a listening session at which any member of Congress was invited to address the committee on criminal justice reforms. Following the listening session, committee staff worked together in a bipartisan fashion to craft legislation that meets the goals of this initiative. The first bill we will consider today is H.R. 3713, the Sentencing Reform Act of 2015. I introduced this legislation along with Ranking Member Conyers, Crime Subcommittee Ranking Member Jackson Lee, Representative Labrador, and a bipartisan group of leaders on this issue. This legislation strikes an important balance between reducing certain federal mandatory sentencing laws and ensuring that these sentencing laws continue to protect the American people from violent criminals. H.R. 3713 makes several significant changes to federal sentencing law. It reduces the mandatory life sentence for a third drug trafficking offense to a mandatory sentence of 25 years and reduces the second strike mandatory sentence from 20 to 15 years. H.R. 3713, in response to a recent court decision, amends federal firearms statutes to clarify congressional intent that stacking of federal penalties requires an intervening arrest and conviction. It broadens the application of the existing safety valve to apply the benefit of sentencing without regard to the mandatory minimum to offenders with prior misdemeanor or nonviolent felony convictions. The bill also creates a second narrowly tailored safety valve for certain offenders facing the 10-year mandatory minimum sentence. Finally, the bill provides for limited retroactivity of the crack cocaine trafficking quantities in the Fair Sentencing Act of 2010. H.R. 3713 also makes the sentencing reductions proposed in the bill retroactive. However, it does not blindly apply retroactivity. The bill excludes from retroactivity any offender who has a prior conviction for a serious violent felony for which the offender served 13 months or more in prison. This means that those inmates will be required to serve their full term of incarceration and will not be released early. I believe this is a critically important feature of H.R. 3713. 3713 contains a sentencing enhancement for fentanyl. Our nation is currently in the midst of a heroin epidemic. Fentanyl, a narcotic pain medication 80 to 100 times more potent than morphine, is often used as a cutting agent for heroin, or is sold disguised as heroin, and has led to a rash of deaths across the country. H.R. 3713 imposes a sentencing enhancement of up to 5 years for trafficking in heroin cut with fentanyl or trafficking in fentanyl represented as heroin. This enhancement must run consecutively to the underlying sentence. H.R. 3713 allows serious violent felony convictions to serve as the basis for a sentencing enhancement for federal drug trafficking. Current law only allows prior drug felony convictions to serve as the basis for a sentencing enhancement. As with the limitation on retroactivity, I believe this is an important change that will enable law enforcement to target the violent drug traffickers who threaten our communities. The Sentencing Reform Act proposes targeted, responsible sentencing reforms. It makes common sense changes to certain federal drug sentences while helping law enforcement keep violent offenders behind bars and saving taxpayer dollars. I want to thank the gentleman from Wisconsin, the chairman of our Crime, Terrorism, Homeland Security, and Investigation Subcommittee, who also chaired our task force on overcriminalization, for working with myself and Ranking Member Conyers on this legislation and for the more than 2 years' work that he has dedicated to this issue as well. I also want to thank the ranking member of the Crime Subcommittee, the gentlewoman from Texas, Ms. Jackson Lee, for her important input in all of these areas related to criminal justice reform as we set out to adopt legislation that we can send to the floor. At this time, it's my pleasure to recognize and also thank the ranking member of the committee, Mr. Conyers, for his hard work and collaboration on this series of bills that we're offering today.
Thank you, Chairman Goodlatte and members of the committee. H.R. 3713, the Sentencing Reform Act, responds to the growing recognition in our states and now in Congress that we must make meaningful reforms to various aspects of our criminal justice system, particularly with reference to mandatory minimum sentences. As with any policy, it's our responsibility in Congress to examine the facts, make adjustments from time to time, and the facts demand that we take action on this issue. We're all too familiar with the most glaring statistics frequently recited. The United States is home to 5% of the world's population, but has 25% of the world's prisoners. Our incarceration rate is 4 times higher than China's. The Department of Justice spends nearly 1/3 of its budget on the federal prisons. And we know that extending incarceration beyond that which is appropriate actually increases recidivism. Therefore, adjustments to our sentencing laws are long overdue, and that's why, as the chairman has suggested, we need to approve this bill. H.R. 3713 is an important reform measure that makes a number of improvements. First of all, it reduces mandatory minimum sentences for prior drug felons. It broadens the existing safety valve to allow more offenders to be sentenced below mandatory minimum drug sentences if in the court's discretion it is warranted. The bill creates an additional safety valve to allow relief for some offenders who would otherwise be subject to the 10-year mandatory minimum for drug offenses. In addition, H.R. 3713 reforms the way prior firearms offenses are considered with respect to application of the mandatory minimum sentence for repeat firearm offenders. And most importantly, the bill retroactively applies the reduced mandatory minimum sentences for crack cocaine under the Fair Sentencing Act. And notably, the bill does all of this without the addition of new mandatory minimum sentences the Senate proposed in similar legislation. These changes will still allow for appropriate punishment and, in my view, will make us safer. They will also save American taxpayers money by reducing the spending associated with needlessly long incarceration, money that should be invested in education, job training, and other productive priorities. We on this committee have worked together, as our constituents expect of us, to find a way forward on this important issue. And the measure before us reflects the recognition that criminal law is a blunt instrument, and it is difficult to achieve just results in every case. So in my view, that is why we must allow judges who are in the best position to know and evaluate all of the circumstances of each case to impose sentences that both hold offenders appropriately accountable and that are just according to the facts. H.R. 3713 does not achieve all of what I and some of my colleagues would want. However, today we have the opportunity on a bipartisan basis to address some of these injustices and to provide retroactive relief for some of those who've been subjected to them. As this committee has done in the past when history has required it, it is my hope that we can and will come together today to take action on a pressing issue for our nation so that we will send a bipartisan message that the House Judiciary Committee can adopt smart and common sense changes to the criminal sentences laws that will help thousands of individuals and their families while also enhancing public safety. I commend all of my colleagues who have worked on this bill and urge its immediate passage. I thank the chairman.
Mr. Chairman,
For purpose, the gentleman from Wisconsin seek recognition.
I move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. Over the past several months, we have seen growing momentum for sentencing reform legislation and mounting evidence for why we need reform. Decades of flawed sentencing laws have swelled the ranks of nonviolent offenders in our federal prisons. The results have led to prison overcrowding, strapped budgets, and diminished well-being for current and former prisoners and the public at large. The Sentencing Reform Act isn't perfect. Evidence-based programs in states like Texas and Utah have shown that we can reduce prison population and save taxpayers' dollars without increasing crime rates. I would have preferred legislation to adopt these proven approaches. However, I credit the chairman with finding a middle ground and working with members of both parties to reach this agreement. I think that to thoroughly vet this and to get the proper balance, it's going to take several Congresses in order to see how these reforms work and whether they need to be tweaked, amended, enhanced, or reduced. And I look forward for the next several Congresses to working with my colleagues to achieve any amendments that we may need to make to this bill in the future. However, the Sentencing Reform Act will eliminate mandatory life sentences for three-time nonviolent drug offenders, reducing those mandatory minimum sentences to 25 years. Like the Safe Justice Act, which I introduced with Congressman Bobby Scott of Virginia, the Sentencing Reform Act will also narrow the kinds of prior drug offenses that can trigger recidivist enhancements, broaden the safety valve, and make the Fair Sentencing Act retroactive. Our system cannot continue on its present trajectory. It's not only fiscally unsustainable, but morally irresponsible. This is a much-needed step forward today. However, I hope we all can agree that we can and we should do more. We must have the courage to tackle prison reform and to strengthen our probation and reentry programs. We should promote the use of drug courts and veterans treatment courts within the federal system, as well as enhanced treatment services for those with mental health or substance abuse disorders. The states have been outperforming Congress in criminal justice reform for years. It is my hope that we can continue to work together in a bipartisan manner to produce legislation that will address the complex problems our current system faces. Now I yield back the balance of my time.
The chair thanks the gentleman. For what purpose does the gentleman from Texas seek recognition?
To strike the last word, Mr.
The
Chairman.
gentleman is recognized.
Mr. Chairman, thank you so very much, and I want to offer my appreciation to the chairman, the ranking member of the full committee, Mr. Conyers, and Mr. Sensenbrenner, for having the common goal of turning the corner on criminal justice reform in this nation. Let me say that today we make a significant statement and take action on reducing and eliminating mass incarceration in this nation. We take leaps of faith to recognize the importance of restoration and rehabilitation. This is not a compromise or a best effort. It is actually a reality of laws, provisions that will in fact be placed in the criminal justice system, giving added tools to defense counsel and prosecutors to have a fair and even playing field for those nonviolent offenders who have come in the crosshairs of the criminal justice system and need another opportunity. It will be a lifeline for families who have waited for years for their loved ones to be released. And no, it will not add to the crime of this country. In fact, it will give more tools to those who will be released to tool this country and make it a better place. So again, I extend my thanks to you and the Ranking Member Conyers, who has a long history of justice issues in this Congress and in the nation. I thank you for the hard work and for the listening session that I willingly and participated in and supported, as well as the overcriminalization effort led by Mr. Sensenbrenner, the ranking member, in the last session, and the many members on this committee, Republicans and Democrats. I want to thank you, particularly those who participated in the overcriminalization task force. Your work has been the embodiment of this legislation, and we thank you so very much for your work. When we began this process, our desire was to form a consensus, not to overstep the values and the heartfelt positions of many on this committee. It was to work step by step to build a consensus, not something often seen over the years, and how befitting it is that a committee that has its hands around the justice system of America could find consensus on such a contentious issue, and one that has hurt so many families across America. We began our task force with the knowledge that truly meaningful reform requires us to look at every piece of the system, from policing to charging and convicting, and from sentencing to the collateral consequences awaiting incarcerated individuals. We set our sights on comprehensive reform that tackles sentencing, prisons, overcriminalization, youth justice, civil asset forfeiture, reentry, policing, criminal procedures, and the most recent addition, mental illness. And I am grateful that the chairman says we will tackle all of those issues. That is an important step. Each piece is critically necessary, but we knew that sentencing reform would truly test the seriousness of our commitment to collaboration. That is why we tackled it head on. As I sit here today, I know that we're not alone in knowing that we've made the right choice working with so many. With the Sentencing Reform Act of 2015, we unify to reject a system that is often more effective at creating criminals and collateral damage than actual justice. Our legislation is strong and thoughtful, as explained by the chairman and ranking member, and as shown by data, it will reduce mass incarceration. Over 11,500 individuals who are currently incarcerated will be eligible for retroactive relief. Over 4,000 more will benefit each year. Combined, that is over 50,000 in 10 years to be restored and rehabilitated. These estimates are conservative, and they're ones that we can move and base our future legislation on. It could be said that other bills, some that have come before and some that will surely follow, will do it differently or go further. But there's something about our legislation that is different, something that gives me hope for our entire reform system. Our bipartisan legislation can get to the president. I ask my colleagues to reflect on this moment. Our current path is unsustainable. We know the numbers. Less than 5% of the world's population, but 25% of the world's prisoners. Ranked number 1 in incarceration. The cost of this system is incredibly high, $80 billion. Worse, this system takes an incredible human toll with the cycle of incarceration. These costs, including the cost to our greater sense of humanity, bring us to this moment. I call on my colleagues to support the Sentencing Reform Act of 2015, H.R. 3713, because these costs are simply too great to bear. Such meaningful reforms would not be possible again without the collaborative work of our chairman and ranking member, and Mr. Sensenbrenner, and all of you who have been so dedicated to this issue. In my service as ranking member of the House Judiciary Committee, Crime Subcommittee, I've been truly humbled to take on this task, one of the most important in my lifetime. Just as our action is one step towards enacting this legislation, the bill is one component of criminal justice reform. I look forward to our continued collaboration on all of the other areas, especially helping our youth in the youth justice system and prison reform. The bipartisan legislation and the leadership here should truly make a difference in the lives of so many. Mr. Chairman, with that, I yield back.
The chair thanks the gentlewoman. For what purpose does the gentleman from Wisconsin
Mr.
seek?
Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 3713, offered by Mr. Sensenbrenner of Wisconsin. Add at the end of the bill the
Without
following.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My amendment does two things. First, it will require DOJ, in consultation with the Sentencing Commission, to issue another report updating the Commission's 2011 Comprehensive Report on Mandatory Minimums. Among other things, the report contains substantial information about the use of pleas, what offenses were dismissed as a part of a plea, sentencing enhancements, and what charges were dismissed. It is important that when reforming our criminal justice system, we need to have the most up-to-date information. Secondly, it expresses the sense of Congress that the growing and serious need to make mental health treatment a central component of criminal justice reform. More than half of federal inmates have symptoms of serious mental illness. Our jails and prisons have become America's mental health facilities, the purpose for which they were never intended. However, with proper treatment, which we know costs far less than imprisonment, offenders can be rehabilitated and safely transitioned back into the community. States have embraced this approach, and so should Congress. I want to thank the ranking member of the Crime Subcommittee, the gentlewoman from Texas, Ms. Jackson Lee, for co-sponsoring this amendment, as well as the gentleman from Georgia, Mr. Collins, and the gentleman from Louisiana, Mr. Richmond. I look forward to working with the chairman and ranking member on this critical component and urge my colleagues to support the amendment and yield back the balance of my time.
Chair thanks the gentleman. For what purpose does the gentleman from Michigan seek recognition?
To strike the requisite number of words.
The gentleman is recognized for 5 minutes.
Thank you, sir. Members of the committee, obviously I support the amendment, but I want to thank the Crime Subcommittee Chairman, Jim Sensenbrenner, and the subcommittee ranking member, Sheila Jackson Lee, and also members Doug Collins and Cedric Richmond for their recommendations of these proposals. We'll benefit from the report from the Sentencing Commission on the use of mandatory minimum sentencing. It's also important that the Congress recognize the need to better integrate mental health treatment as part of our reforms effort. And for those reasons, I urge the adoption of this amendment and yield back the balance of my time.
The chair recognizes himself in support of the amendment. I appreciate the amendment offered by the chairman of the Crime Subcommittee, Mr. Sensenbrenner, the ranking member of the Crime Subcommittee, Ms. Jackson Lee, the gentleman from Georgia, Mr. Collins, and the gentleman from Louisiana, Mr. Richmond. This amendment expresses the sense of Congress that meaningful criminal justice reform requires the integration of a mental health component as part of a comprehensive reform strategy. It also requires the Justice Department to issue a report on the mandatory minimum sentencing provisions in federal law. As my colleagues are all aware, part of the committee's criminal justice reform initiative will include consideration of legislation to reauthorize programs designed to treat and assist mentally ill offenders. I agree with my colleagues that this is an important component of the criminal justice reform initiative. I look forward to working with the gentleman from Wisconsin, the gentlelady from Texas, the gentleman from Georgia, and the gentleman from Louisiana, along with other members of the committee to whom I know this is important as we move forward with this process. As to the reporting provision, in 2011, the Sentencing Commission issued a comprehensive report on mandatory minimums. Given that this committee is moving legislation changing some mandatory minimum sentences, the responsible thing for us to do is ensure that our actions are evaluated by the federal agency that enforces these laws. I support the amendment, and I urge my colleagues to do the same. For what purpose, the gentlewoman from Louisiana seek I'll get to the gentleman from Louisiana. The gentlewoman from Texas seek recognition.
That's all right. We're neighbors, Mr. Chairman. Thank you so very much. And I am going to thank you, Mr. Conyers, Mr. Sensenbrenner. I want to thank him for leading on this amendment, and delighted to be able to join him along with Mr. Collins and my neighbor, Mr. Richmond in Louisiana, all who have expressed and often commented on the intervening factor of mental illness. We know that law enforcement spends a disproportionate amounts of time interacting with individuals with mental illness, not because of criminal conduct, but other behavior related to crisis or that is viewed as problematic in a community. Every day, we are facing the various array of stories that provide us with a sad commentary on the confrontation of someone suffering from a mental illness, a mental health crisis, who comes in contact with law enforcement. We realize that this is, again, another scourge that we must address in a positive way. In fact, law enforcement have come before this very committee and expressed a desire for increasing mental health and social services over budgets for incarceration and policing. Let me say I've had firsthand experience dealing with some of these issues in my own jurisdiction. Example of a young man who had a mental breakdown and was incarcerated in our local prison, local jail, and created enormously difficult conditions for himself and rejecting all help from the jailers. Family was not able to see him because there was no mental health component in the jail, and I worked to get that system put in the jail to be able to deal with those who are even incarcerated already who have a mental health concern. So I am very pleased that this amendment includes an order to the Sentencing Commission to conduct a study on mandatory minimums and their relationship to unwarranted sentencing disparities. And I'm delighted that in this bill we will have a placeholder and an articulate statement on the vitalness of understanding mental health crises and how it interrelates to policing, criminal justice, and ultimately incarceration. I thank my ranking member, for his work, the chairman of the full committee, and I particularly thank Mr. Sensenbrenner for his efforts. With that, I yield back.
The chair thanks the gentlewoman. What puts the gentleman from Louisiana seek recognition?
I would like to speak in support of the amendment.
The gentleman is recognized for 5 minutes.
First, I'd like to thank Mr. Sensenbrenner for his hard work and the long track record of work that he has on criminal justice reform and introducing this amendment, and thank both the chairman and the ranking member for supporting the amendment. And I think that it does two things. One, it shows how much work we still have to do in getting to a point of comprehensive criminal justice reform. Two, it highlights the fact that too much of our mental health services are happening in prisons as opposed to other facilities. And as states balance difficult budgets, mental health has been one of the things that was always on the chopping block. And we in society are paying for that dearly, and this amendment highlights that. But the other thing it does is reinforces the work we still have to do. Under this bill, 50,000 nonviolent drug offenders have the possibility to be released over the next 10 years. We release 650,000 ex-offenders every year from prison, and our recidivism rate is over 50%. So that means over half of them are going to wind up back in the system unless we spend effort, time, and commit resources to not only mental health, but those programs that will reduce recidivism. So making sure that when people get out, they have stable housing, that they can find employment, that we can deal with mental health, and that we can start to renew family relationships. Because one of the things that we find is that although the incarcerated person may actually be in the confines of a jail, but it's the family that's doing time. And we have to make sure that we continue to have those sort of connections so that we can have support systems for people when they get out. Because the purpose of the bill and the purpose of criminal justice reform at the end of the day is to make our communities safer and to help reform people who need reform. So with that, Mr. Chairman, I would just like to, again, support the amendment because the data collection is also important, and the recommendations and the report on mandatory minimums, because I think what's important here, and we should always stress, is that all the decisions are being made based on data and proven evidence, so that we are making scientific decisions in terms of how to keep the community safe, and we're not just going off of what we think and what we believe, but we're using experts who deal with this every day so that we can protect society. So with that, Mr. Chairman, I will thank the author of the amendment, and I will thank the chairman and the ranking member who also have a long track record on criminal justice issues.
The chair thanks the gentleman. The question occurs on the amendment offered by the gentleman from Wisconsin. All those in favor will say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment is agreed to. Are there any other amendments? For purpose, the gentleman from Colorado seek recognition.
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 3713, offered by Mr. Buck of Colorado. At the appropriate place.
Without objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This amendment exempts heroin offenders from any provisions in this bill that would change current law. In other words, this amendment preserves the tools that prosecutors and police need to face the heroin epidemic in America. Heroin is a scourge on our country. In the past decade, heroin overdose deaths in America have increased fourfold. 8,200 people died from heroin use in 2013. Between 2002 and 2004, 379,000 people reported using heroin. Nearly a decade later, that number had grown to 663,000. Greater than half of the 120 people who die from drug overdoses every day in the U.S. are killed by heroin and painkillers. The drug has its grip on our youth. In the last decade, heroin use doubled in the 18 to 25-year-old age group. Heroin cartels, largely from Mexico, have unprecedented reach. In 2005, only 228 pounds of the drug was seized on our southern border. In 2014, that number increased to 9,205 pounds, and that's only what we caught. This amendment leaves mandatory minimum sentences in place for heroin-related offenses. As a prosecutor, I can speak of the advantage of these minimum sentences. When a young man, a cog in the wheel of a big drug organization, is looking at 20 years of his life behind bars for selling heroin, he starts thinking straight. In return for a lesser sentence, prosecutors can convince him to give up the kingpins, the ones whose hands are really red with the blood of thousands of American overdose deaths. The young man pleads to a lesser sentence and hopefully rebuilds his life after a few years in prison. The kingpins face the justice they deserve, decades behind bars. I'll point to comments from my honorable colleague, Mr. Rangel from New York. Witnessing the toll that drugs took on families in his Harlem district decades ago, he argued for a tough stance on drug issues. He said, "We need outrage. I don't know what is behind the lackadaisical attitudes towards drugs, but I do know that the American people have made it abundantly clear they are outraged by the indifference of the U.S. government to this problem. In decades since, we've not only been indifferent, but we can't fall back into a lackadaisical attitude about a drug that ravages our communities as much as heroin." I'll close with a story I read in the Washington Post. It's about Morgan Brattain, a 19-year-old in Portland, Oregon. In May 2013, Brattain overdosed on half a gram of black tar heroin. She spent 4 months in a coma. She survived the overdose, but the scars will last a lifetime. She can't walk, can't eat, can't write, and has trouble speaking. Morgan is one of thousands of youth each year who face death and disability by heroin. To save these lives, we need to dismantle the organizations that supply heroin, and to do that, our prosecutors and police need the tools currently in their toolkit, including mandatory minimums. With these tools, we can secure a better, safer future for our children. Mr. Chairman, based on our previous conversations and the opportunity to improve this bill at a more appropriate time, I will withdraw this amendment, and I yield back the balance of my time.
Without objection, the gentleman's amendment is withdrawn. The chair thanks the gentleman and looks forward to working with him on the issue. What purpose does the gentleman from South Carolina seek recognition?
Seek recognition.
The gentleman is recognized for 5 minutes.
Very briefly, Mr. Chairman, I just want to commend the gentleman from Colorado, first of all, for his service to the state of Colorado as a prosecutor, and also to the United States government as an assistant United States attorney, for highlighting the heroin epidemic, which as the gentleman from Colorado knows, is actually a bipartisan issue. Our friend and colleague from Massachusetts, Mr. Kennedy, was also a prosecutor, and he has spoken eloquently about the heroin epidemic. So I want nothing more than to commend my friend from Colorado for highlighting this issue, and hope that he continues to do so. With that, I would yield back.
Chair thanks the gentleman. For purpose, the gentleman from Georgia seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you for this proposal that actually moves us towards a solution to the problem of mass incarceration that has afflicted our society since Richard Nixon declared war on drugs. And this mass incarceration has afflicted disproportionately, just as the heroin epidemic of the 70s disproportionately affected people from inner city neighborhoods, black folks. We have borne the brunt of this mass incarceration, which this legislation seeks to change course. It's a modest proposal that I congratulate the chair of this committee, the ranking member of this committee, and also the chair and ranking member of the crime subcommittee of this committee. But I don't want us to move backwards because of this scourge of heroin that is now afflicting suburban neighborhoods. It's now getting the attention that it certainly deserves. But at the same time, we don't want to go back to mass incarceration for a public health problem. And I'll point out, after having practiced criminal law for 27 years as a defense lawyer, that when deals are, when street-level drug dealers, drug dealers are the ones who generally get caught up in these drug stings, and they are the ones who get sent to prison. They don't know who the big kingpins are. And whenever you do find out who a kingpin is, it's the kingpin that has the leverage to negotiate a good deal with the prosecutor. They end up being able to keep all of their property, being able to get their time cut, so long as they can testify about everybody down line. They can deliver more bodies to the prosecution to lock up, thus feeding the mass incarceration. With that said, Mr. Chairman, I will yield back.
Chair thanks the gentleman. For purpose, the gentleman from Texas seek recognition.
Thank you, Mr. Chairman. Move to strike last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. And I know you've worked very hard to get input from all of us. We got a letter here dated November 16th from Stephen Cook of the National Association of Assistant U.S. Attorneys as their president, and he expresses concerns about our bill, and their opinion is that the nation will suffer higher crime rates, higher taxpayer costs, greater human turmoil, and desperate justice throughout the federal courts, and urge us not to pass this. But I felt like the AUSAs that are enforcing the law should have their voices heard, and would ask unanimous consent to submit this as part of the record.
Without objection, that letter will be made a part of the record.
And then I'd yield back. Thank you.
I just want to note for the record that during the overcriminalization task force hearing on penalties, we did hear from Mr. Eric Evanson, who appeared on behalf of the National Association of Assistant U.S. Attorneys, and we will continue to work closely with them and other interested groups as we continue with this process. We have been in contact with them, and I have met with them individually as well, and I know other members have as well. So we definitely welcome their input into this process, and they have been heard.
Chairman.
Are there further amendments? For purpose, the gentlewoman from Texas seek recognition.
Strike the last word. Let me recognize the gentleman from Colorado for his concern and thank him for his concern. Certainly, this is re-raging again. My good friend from Georgia has delineated the siege that we found ourselves in urban neighborhoods. Many of us grew up in those same neighborhoods and saw this right in our reach. And so we're not unfamiliar with heroin and its devastation. The statement that is being made by this legislation is by no means ignoring the scourge of any drug. What it is saying is that we are giving other tools to be able to restore people who have served more time for an approach to drugs that we have found that has not been the most direct in solving the problem. I think we have to look at heroin. We have to come with, again, additional tools. But we know many of this is engaged in mental health issues. My state, Texas, has been a leader on trying to craft a pathway for reduction of incarceration, eliminating a mass incarceration but still keeping citizens in the state of Texas safe. And we've been successful, and I want to congratulate them. So I know the work that Congressman Rangel did. He was on the Select Committee on Narcotics. At that time, heroin was in the siege, as it is seemingly becoming now. And he was asking the nation to take notice of how do we stop the heroin from coming into neighborhoods that he represented. I know the story very well. And so I think we can find a pathway, and I think that pathway can work very well in keeping the sentiment and the basis of H.R. 3713, which also brings about the release or the coming down of mass incarceration without diminishing the safety and security of the American people. So I thank the gentleman for his comments, and I know that we will look forward to working with him. I yield back.
Chair thanks the gentleman. Are there any other amendments to H.R. 3713? For purpose, the gentleman from Colorado seek recognition.
Have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 3713, offered by Mr. Buck of Colorado. At the appropriate...
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Mr. Chairman, my amendment will call on the Attorney General to publish the name of every offender whose sentence is reduced retroactively through this bill, those offenders' criminal histories, and a notification if an individual released due to the provisions of this bill is arrested or charged with a crime. The lawmaking process shouldn't end when a bill is passed. We have a responsibility to make sure our laws actually work. The bill we're considering will result in the early release of many prisoners. My amendment measures the consequences of this bill to help us understand how reduced sentences affect recidivism. This amendment will help us better understand the risk factors that lead an offender to commit further crimes, helping us to improve our nation's criminal justice system. Requiring this transparency is vital because many of the crimes in our country are committed by reoffenders. In a massive Bureau of Justice Statistics study across 30 states, 76.6% of released prisoners were arrested again within 5 years. These statistics hold across different types of offenses: violent, property, drug, and public order. In fact, 77% of drug offenders were arrested within 5 years of release, compared to only 71% of violent offenders. As we consider who should serve shorter versus longer sentences, we need to be sure we're not releasing criminals back onto the street to commit the same or worse crime. Transparency and careful legislating are especially important at a time like this. In a speech last month, FBI Director James Comey stated, "More people are being killed in America's cities this year than in many years." And let's be clear, far more people of color are being killed in America's cities this year, and it's not the cops doing the killing. He continued, most of America's 50 largest cities have seen an increase in homicides and shooting this year, and many of them have seen a huge increase. Crime may be spiking this year, but we've felt the effects of crime, and more specifically recidivism, for a long time. My state of Colorado especially knows the consequences of repeat offenders. Since 2002, at least 33 former prisoners on parole were accused of 38 murders. One of those was the cold-blooded assassination of Tom Clements, the executive director of the Department of Corrections. Other released prisoners in Colorado threatened to go on mass shooting sprees or bomb a high school in Denver. Our lesson from these grim statistics: crime clearly directly impacts the American people. With sky-high recidivism rates and increasing violent crime across the United States, we owe it to our constituents to take great care with policies that would put future criminals back on the street. My amendment will allow us to take great care and would add transparency to the process. And Mr. Chairman, again, I will withdraw this amendment given our conversations, and thank the chairman and the ranking member for their work on this bill, and understand that we will continue to look at different ways to improve this legislation. I yield back my time.
Without objection, the amendment is withdrawn, and the chair thanks the gentleman. And for what purpose does the gentleman from Louisiana seek recognition?
Strike the last word very quickly.
Gentleman's recognized.
Just in case the gentleman from Colorado has an interest in pursuing that line, I would just offer to work with him, because even if you look at the movement now to ban the box and have employers not look at criminal history until after they've made a decision whether they're interested in the candidate, I understand exactly what you're trying to do, and I think there's some value to it. But I'm also concerned that it would defeat the process in terms of banning the box. So if we can work together and see if there's some common ground, I'd love to do that. But I'm worried about making it a self-fulfilling prophecy, so that when someone gets out and everybody knows he's an ex-offender, if he can't legally get a job and provide for his family, then it pushes him either into a state of depression and hopelessness, or it pushes him back into a life of crime. So maybe we can find some middle area there, and I'm just speaking from my experience of helping ex-offenders. So I'm willing to work with you, is the short answer of all of that I just said.
Thank you.
And with that, I'll yield back.
Chair thanks, gentlemen, and would also be willing to work with both gentlemen on that issue. For purpose, the gentlewoman from California seek recognition.
I would also like to strike the last word.
Gentleman was recognized for 5 minutes.
Thank you, and express my interest in working with the gentleman as well. One of the things that we've certainly seen in California, where the courts required us to reduce the number of inmates because our prisons were too overcrowded, is that we let people back on the street. But over the years, we had passed over 50 bans on various occupations. For example, one was barbering. We had a program in our state prisons to teach people how to barber, but then we wouldn't let them have a license. And so we have to figure out how to reintegrate people back into society, or it actually has the opposite effect in a lot of neighborhoods. It increases crime, because if people can't work in the legal economy, they'll sure enough work in the illegal economy. So I look forward to working with the gentleman as well to help get people back reintegrated into society. But Mr. Chair, I wanted to commend you and the ranking member and the crime subcommittee ranking member, Jackson Lee, for their work on this bill. H.R. 3713 is an important step in the right direction on criminal justice reform, but there's a lot of room for improvement in this bill, and more broadly, there's a lot of room for improvement in the conversations we're having about criminal justice reform. Regarding this bill, I was prepared to offer an amendment that would narrowly define conspiracy and relevant conduct under the drug code, so that people are sentenced for what they knowingly and willingly do. The reason we should add such a provision is that too often young women get caught up with the wrong guys, basically, where they are not intentionally involved in drug dealing, but the men are involved in drug dealing, and they either inadvertently get involved in the drug operations, or they're physically or emotionally abused and coerced into being involved. So when the police make a raid, they're detained, charged, and sentenced as co-conspirators. And I wanted to cite one case of a young woman named Danielle Metz from New Orleans, from my colleague next to me, his district. She was in an abusive relationship with a drug dealer who physically beat her and rarely let her leave the house. She was afraid to leave him because he was violent, but she also felt guilty about separating him from their 2 young children. So twice he made her pick up and transport cash related to his drug enterprise, and she got indicted as a co-conspirator. She is now thousands of miles away from her family, actually in my state, serving the 22nd year of a life sentence. She wasn't a trafficker or a kingpin. She was a young woman stuck in a bad situation. Yet due to mandatory minimums, the court convicted her for handling drug money, which she did out of fear for her life. Despite being a first-time nonviolent offender, Danielle was sentenced to life in prison. The amendment I was prepared to offer would ensure that a person like Danielle can't be convicted of conspiracy. She would have to intentionally have participated to be charged and sentenced. So that's one area of the bill that I wanted to improve, but I'm not going to offer the amendment. But I wanted to give another example talking about criminal justice more broadly. I bet many of my colleagues are not aware that incarcerated women are chained down while giving birth, despite the fact that this practice is inhumane and opposed by medical professionals. In Illinois, 80 inmates won a $4.1 million class action suit for being shackled while pregnant or in labor. In Nevada, the State Board of Examiners paid $150,000 to an inmate who suffered bone separation because she was shackled during labor. In fact, federal courts have condemned such shackling as an Eighth Amendment violation. In 2009, Eighth Circuit Court, Nelson versus Correctional Medical Services, the court said that shackling a pregnant prisoner during labor was clearly a violation of the Eighth Amendment. A federal case out of Tennessee held that shackling of a pregnant detainee in the final stages of labor shortly before birth and during postpartum recovery violates the Eighth Amendment. Again, I think that there's many areas in our criminal justice system that we need to look at. This is clearly one. I realize it's outside the scope of the bill, but I did want to raise this in hopes that the chairman and the ranking member will continue our dialogue around criminal justice reform once we dispense with this legislation today. And I yield back my time.
The chair thanks the gentlewoman. Are there any further amendments to H.R. 3713? A reporting quorum being present, the question is on the motion to report the bill. For the purpose, the gentleman from New York.
Strike the last word, please.
The gentleman is recognized for 5 minutes.
Thank you. Mr. Chairman, first of all, before I say what I had prepared to say, I just want to comment that the story just told us by the gentlelady from California of that young woman sentenced to life imprisonment because she was involved with her boyfriend, her abusive boyfriend, and got a mandatory minimum of life is exactly why what Mr. Buck said earlier is wrong. She got a mandatory minimum because she didn't know a kingpin to give up. And these mandatory minimums often have the perverse result of a kingpin who knows other kingpins getting a light sentence, and the guy low on the totem pole who didn't do that much, having nobody to give up, having no leverage in the plea bargaining, and therefore getting a terrible sentence. Or even someone innocent who, facing a huge sentence and a huge legal expense and not having a lot of money, may plead to a lower case to avoid the mandatory minimum, even though they're innocent. So there are real problems here that we have to address. Now, sentencing reform is critically important, and I appreciate the chairman, Mr. Goodlatte, and the ranking member, Mr. Conyers, and the crime subcommittee ranking member, Chairman Sensenbrenner, and ranking member Jackson Lee for their work on this. And I will support the bill because it makes some improvements to the current law. But I should note that my vote is with considerable hesitation. I'm concerned that some of the enhancements of sentencing in the bill, while we are assured that they only go so far and they only affect a small number of people, it's not clear that that is true. I'm concerned that we don't know the effect and the magnitude of the effect of some of the changes this bill would make, particularly with respect to heroin and fentanyl. And we run some risk that we could go in the opposite direction in some ways. So I wish we had more research and more data before we voted on this. The new consecutive sentencing enhancement, as I said, for heroin mixed with fentanyl could send yet more people, particularly African Americans, to prison for lengthy sentences. We don't know how judges will apply this provision, and because although we are told that there are only 8 or 9 such cases that we know about with fentanyl, since fentanyl mixed with heroin has not been an aggravating cause, it may be that many people were sentenced for heroin where there was also fentanyl, and when we make it an aggravating cause, we will find that this provision has a much further effect than we believe now. So this bill makes a start in the right direction. I will support it. It doesn't go nearly far enough, but equally importantly, for not going far enough, that's never a reason to vote against the bill. I shouldn't say never. It's rarely a reason to vote against the bill that it makes an improvement, but not a big enough improvement. But there is some risk that this bill could actually go backwards. I don't really believe that, but I wish we had more research to indicate the scope of some of the new provisions we're putting in. With those reservations, I will I will support the bill. And in the hope that we know that this is not the solution to the problem, but the first and step in the direction we have to go, because we have to go a lot farther than this. I thank you. I yield back.
Chair, thanks, gentlemen. Are there further amendments to H.R. 3713? A reporting quorum being present, the question is on the motion to report the bill H.R. 3713 favorably to the House as amended. Those in favor will say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will report as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 4002 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4002 to amend Title 18 United States Code to make various improvements in federal criminal law and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. Today we consider H.R. 4002, the Criminal Code Improvement Act of 2015, introduced by Congressman Jim Sensenbrenner, the chairman of both the Crime Subcommittee and the committee's Overcriminalization Task Force in the last Congress. At the task force's first hearing, the witness panel unanimously agreed that the erosion of the mens rea requirement in federal criminal law was the most pressing issue facing the task force. Indeed, during the remaining 9 hearings held before the task force, we heard time and again about the problem of inadequate criminal intent requirements. This erosion, along with the expansion of the federal code to nearly 5,000 criminal statutes today, as well as hundreds of thousands of regulations carrying criminal penalties, has resulted in a code that no average American citizen could be expected to read and understand, let alone conform his conduct to. As a result, the news is replete with stories of Americans who have been convicted of crimes and sometimes sentenced to prison terms when they had no intent to break the law. Of course, one of the main problems that led to this predicament is Congress itself. Recent Congresses have crafted scores of new federal criminal laws that lack adequate criminal intent requirements and define the criminalization conduct in unacceptably vague, overbroad terms. However, we have already taken important steps to fix this problem. Earlier this year, at my direction, the Judiciary Committee sought and received a change to its Rule 10 jurisdiction. This change, which adds the word criminalization to our jurisdiction, will ensure that this committee will be able to receive a sequential referral whenever a bill amends the conduct associated with a criminal offense, not just the penalty. H.R. 4002 takes the next big step in this process. It makes a number of important changes to Title 18 of the U.S. Code. Most notably, it establishes a default mens rea standard of knowingly, which will apply in cases where federal criminal law, including long-standing statutory law and established case law, does not provide a state-of-mind requirement for the particular offense. H.R. 4002 also provides that in situations where a reasonable person in the same or similar circumstances would not know or would not have reason to believe that his conduct was unlawful, the government must prove that the defendant knew or had reason to believe the conduct was unlawful. This provision will address the problem of inadequate criminal intent requirements in crimes created by agency regulation, or malum prohibitum crimes. This is a very carefully crafted bill. Its intent is not to impose a knowingly requirement for every element of every statute. Its intent is to impose a mens rea provision where none currently exists, to protect American citizens who did not know or have reason to know that they were violating federal law, and to curb strict liability criminalization. I thank the gentleman for Wisconsin for his work on the task force and encourage my colleagues to support this important legislation.
Mr. Chairman,
For purposes, the gentleman from Michigan seek recognition.
strike the requisite number of words.
The gentleman from Michigan is recognized for 5 minutes.
Thank you. Members of the committee, H.R. 4002, the Criminal Code Improvement Act, was introduced to follow up on the work accomplished in the last Congress by the committee's task force on overcriminalization and overfederalization. The task force held hearings on a number of problems with federal criminal law, including issues of fairness and due process raised by imposing criminal sanctions and the consequences of a criminal record on individuals convicted of offenses that do not have an intent requirement. To address these matters, the most notable change to the law made by H.R. 4002 is the creation of a default criminal intent or mens rea requirement for offenses where no state of mind is required by law. This default rule would apply to offenses where both the underlying statute, including regulations implementing the statute, and the case law interpreting the statute do not have a criminal intent requirement. In these instances, the bill would establish a knowing criminal intent requirement for these laws. In cases where a reasonable person in similar circumstances would not know or have reason to know that conduct is unlawful, the bill would further require proof that the defendant knew or had reason to believe that their conduct was unlawful. Such strict liability laws, generally designed to provide corporate accountability for harm such as damage to the environment or food safety, are often misdemeanors, providing for fines in less than 1 year of imprisonment as the maximum penalty. On the one hand, the prospect of a criminal record, even if a misdemeanor, may provide sufficient incentive for corporate actors to comply with regulations protecting the public. On the other hand, we should be careful not to impose criminal liability inappropriately in some cases. Overall, the intent of the bill is to disrupt as little as possible current law and to apply only to a narrow range of offenses completely lacking in an intent requirement. Now, I appreciate that many of my friends in the public interest and criminal enforcement community strongly believe that the bill before us goes too far in insulating those responsible for misconduct and urge that it be narrowed to adequately protect public safety. Among other things, they've raised concerns about the bill's scope, about its retrospective application to laws already in place, and about creating new standards in our criminal law. And I am sensitive to these concerns and hope that we would review them as we move forward. We have some discussion going on with the Center for American Progress as well as the Leadership Conference on Civil Rights. And so I want us to keep these ideas in under our review, and I thank the chairman and yield back the balance of my time.
The chair thanks the gentleman and recognizes the gentleman from Wisconsin for his opening statement.
Mr. Chairman, and I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, thank you. During the 113th Congress, I chaired the Overcriminalization Task Force. Its mandate was to conduct a comprehensive review of the overcriminalization in the federal criminal justice system. The task force held 10 hearings on a wide variety of topics, from regulatory crime to penalties to over-federalization. Two topics that permeated the issues facing the task force were the lack of consistent, adequate criminal intent requirements, the need for criminal code reform to address the unwieldy and ever-growing federal criminal code. H.R. 4002, the legislation I authored following the conclusion of the task force's work, addresses those issues. Most notably, it creates a default mens rea standard for federal criminal laws, which will apply in the limited situation where federal law does not provide an intent requirement. In the last several sessions of Congress, I have sponsored legislation to rewrite the entire federal criminal code, and I am pleased to continue that project in this legislation. That legislation, just as H.R. 4002 does, would bring uniformity to the code by using the term knowingly to define the requisite intent for every crime, except for those criminal offenses that require some additional and more specific intent. H.R. 4002 is a significant step toward meaningful criminal code reform. A common criticism of the expansion of the federal criminal code is that it is included in an erosion of the mens rea requirement. This has not occurred, generally speaking, in historically common law criminal offenses, particularly malum in se offenses like murder, arson, or rape. That problem is most acute in the so-called malum prohibitum offenses, that is, offenses that are crimes merely because Congress has decided to pass a law saying so. Many of these offenses are created by unaccountable, unelected bureaucrats in federal regulatory agencies, rather than in congressional committees with expertise in criminal law. As a result, far too often they have no guilty mind requirement, which means that American citizens can be convicted of crimes and sometimes serve jail time for unwittingly committed crimes such as failing to file paperwork or fishing without a license. Vague definitions of these mala prohibita laws and other poorly drafted laws ensnare otherwise law-abiding American citizens who did not intend to break the law and who believed in good faith that their conduct was lawful. This is an unacceptable state of affairs and surely not what Congress or America's common law system intended. H.R. 4002 is intended to fix that problem. In addition to the mens rea provision, H.R. 4002 makes several common-sense changes to modernize, reorganize, and streamline Chapter 1 of Title 18, including the inclusion of universal definitions for commonly used terms. As Justice Robert Jackson explained some 60 years ago, quote, "The contention that an injury can amount to a crime only when inflicted by intention is no provincial or transient notion. It is universal and persistent in mature systems of law as belief in the freedom of the human will and the consequent ability and duty of the normal individual to choose between good and evil." I urge my colleagues to support this important historic legislation and yield back the balance of my time.
Chair thanks the gentleman. Gentleman, for what purpose does the gentlewoman from Texas seek recognition?
I thank the gentleman. I would like to strike the last word.
Gentlewoman is recognized for 5 minutes.
Thank you, Mr. Chairman. Let me just very quickly, before I begin on this, to indicate to the gentleman from New York and the gentlewoman from California that as we begin to move forward on all of these bills, we will take the concerns. But it is important to note that 3713, our bill on sentencing, only applies to offenders facing mandatory minimums. And this comparison illustrates the terms in this bill are substantially narrower than existing law. It makes a difference. And I look forward to working with them, particularly Ms. Bass, on the issues of conspiracy and certainly how pregnant women are treated. I think it's important to note that we've made a strong effort going forward, and I look forward to working with them on their concerns. As it relates to the bill, underlying bill that is now before us, I want to again thank Mr. Conyers and the chairman and the subcommittee chairman, Mr. Sensenbrenner, for their work on this concern of mens rea in the Criminal Code Improvement Act of 2015. What it lacks in quantitative impact, however, it makes up with principle that has deep roots within our system. And as we look at those who are supporting this legislation and those who raise concerns, we will have an opportunity to continue to work with you, the Centers for American Progress, certainly the American Bar Association. But we realized that we had to do something where many of these particular offenses had no knowing or mens rea and had innocent people actually incarcerated based upon an action that they did not know at that time might have been criminal. The vast majority of criminal offenses contain or are interpreted to contain a criminal intent requirement, but offenses that do not can put law-abiding individuals at risk of prosecution. This legislation offers a narrow and measured response to this problem. The rule will directly impact strict liability misdemeanors that have been been used against conduct that was particularly egregious and conduct that was innocent or well-intentioned. The FDA has used this strict liability offense against egg producers who knew and took active steps to hide the fact that their eggs were contaminated and other violations of regulations. That's egregious behavior, and we think that that is a positive way to impact the American public. The FDA also used this strict liability offense to punish farmers who received a superior rating by a third-party auditor and had no reason to believe they were doing anything wrong, clearly non-culpable behavior. In both cases, the food product caused substantial harm, but because the offense does not require intent, the farmers were prosecuted for the same offense as the egg producers. The farmers' culpability, blameworthiness, and knowledge was irrelevant under the law. So it is important that as we look at this legislation, we realize that it is going to help persons who are in benign circumstances but are held to a strict liability. Although the farmers receive sentences of probation, the egg producers receive short prison sentences, that the wildly divergent conduct constitute the same criminal offense and could be punished the same speaks to the flawed nature of this strict liability standard. I believe as we make a first step with this legislation, we have the opportunity to continue to work and make it better. The default rule proposed in this bill would differentiate between these individuals. That said, some have raised concerns that this rule would make it too hard to prosecute blameworthy individuals and negatively impact deterrence among others. I take these concerns seriously and raise them as we develop the legislation. The legislation as introduced is a combination of recognizing our concerns, and I'm glad of that. I want to commend the chairman and the bill sponsor for listening to these concerns and working with us to revise this important bill. I want to add my appreciation to staff that have worked collectively on all of these bills and, of course, have taken the concerns of members and continued in ongoing negotiation. The principle behind this reform is truly worthwhile. Individuals who intend to comply with the law and have no reason to believe their conduct is unlawful should not be subject to criminal punishment. I appreciate that some concerns persist, and I look forward to examining them with my colleagues in a spirit of consensus and collaboration as we move forward in the legislative process. I think the work we've done on this speaks to the question of justice, which is the role of this particular committee, and I'm very glad that we're moving forward to improve justice in this nation. I yield back.
Chair thanks the gentlewoman. What purpose does the gentleman from Texas seek recognition?
Mr. Chairman, I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. As a former prosecutor, judge, as many of you here are, the issue has always been guilty mind. The basis of our criminal law is that there must be guilty intent, guilty mind, mens rea. We have, in my opinion, way too many federal offenses that do not require guilty mind. That surprises me because guilty mind, mens rea, is the basis of American criminal jurisprudence. Some in the Justice Department, district attorneys associations are concerned of the unintended consequences. I understand those concerns, but it's ironic to me the unintended consequences might be really the intended consequences, which should be, if you commit a crime in this country and it's a federal offense, generally speaking, except for statutory strict liability cases, generally speaking, you should have intent, criminal intent, guilty mind. And I hope that is the intended consequence of this legislation. So I commend the chairman and, for this piece of legislation where the federal government needs to get out of the business of prosecuting people with no criminal intent. And I yield back.
The chair thanks the gentleman. Are there any amendments to H.R. 4002? First, the gentleman from Georgia State recognition.
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 4002, offered by Mr. Johnson of Georgia. Page 15, strike
And I ask
line.
that it be considered as read.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. Subchapter C of the Criminal Code Improvements Act creates a default criminal intent or mens rea requirement for offenses where no state of mind is required by law. While the majority of criminal statutes contain a mental state requirement, usually knowingly or willfully, public welfare statutes do not contain this requirement to ensure the broadest protection of the public or environment. For over a century, these statutory offenses, which are misdemeanor offenses punishable by civil fines or less than 1 year of imprisonment, have placed the burden of compliance on those who are in the best position to ensure safe products and activities rather than the public, which is endangered by unsafe products and activities in the marketplace. A Supreme Court, or the Supreme Court, has upheld the validity of strict liability misdemeanor offenses for nearly a century. In 1909, the court held that a corporation may be held liable for the actions of its employees. In 1943, the court expanded this doctrine to hold that responsible corporate officers may also be held liable under public welfare statutes. In 1975, the court again affirmed the responsible corporate officer doctrine and held that while demanding, this doctrine was no more stringent than the public has a right to expect of those who voluntarily assume positions of authority in business enterprises whose services and products affect the health and well-being of the public that supports them. This bedrock legal framework continues to define the relationship between corporations and public safety. And as the White Collar Defense Bar has acknowledged, although this enforcement tool is potentially far-reaching, it is typically reserved for the most rare and egregious cases. For example, this doctrine was applied under the Food, Drug, and Cosmetic Act to hold corporate officers accountable for the Salmonella peanut outbreak of 2008, the largest outbreak of foodborne illness in U.S. history, as well as for the sale of an untold number of eggs contaminated with Salmonella that resulted in thousands of severe illnesses. In sentencing the corporate officers in this latter case, the federal judge observed that not only would strict liability protect the public from additional crimes that the defendants may commit in their individual capacities, it would also serve to effectively deter against the marketing of unsafe foods and widespread harm to public health by similarly situated corporate officials and other executives in the industry. So in other words, general deterrence. In other words, we have laws on the books passed by Congress, used by prosecutors in only egregious cases, and repeatedly upheld by the courts that are critical enforcement tools for ensuring the public's health and safety. These laws have nothing to do with so-called regulatory crimes addressed today. By establishing a default rule for federal criminal offenses that currently lack a mental state requirement, however, The Criminal Code Improvement Act would eliminate strict liability misdemeanor offenses, including food, drug, and wildlife protection laws, among others, and instead require that prosecutors demonstrate that the defendant had knowledge of the facts giving rise to the offense and, in certain cases, had knowledge of its unlawfulness. Additionally, by establishing a variable mental state requirement for these offenses, not only would this bill undermine the responsible corporate officer doctrine, it would also depart from centuries of jurisprudence, firmly establishing that ignorance of the law is not a defense to jeopardizing the public's health and safety. Notwithstanding these serious concerns, I appreciate that we are working to pass bipartisan legislation that is the first step in ending policies that have resulted in mass incarceration. I further recognize that the Chair has made many good faith efforts to address concerns with the default mens rea language in H.R. 4002, and as with all compromise legislation, there may always be some concerns that go unaddressed. But it's my understanding that the Chair will continue to work across party lines to ensure that some of our nation's most important federal welfare laws are not inadvertently disturbed by this bill. And with that understanding in mind, I will withdraw this amendment.
Chair thanks, gentlemen. Without objection, the amendment is withdrawn. Are there other amendments to H.R. 4002? For the purpose, the gentleman from Texas seek recognition.
To strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman, and it is good that we're taking this up. This has resulted in people who intended no legal violations, knew of no legal violations, and yet ended up going to jail or prison, and the unintended consequences, as that term has been used, of putting people in prison who shouldn't have been there in the first place. When you couple that kind of strict liability without mens rea or guilty intention with the laws that also need to be cleaned up that have allowed bureaucrats in cubicles in executive office buildings to come up with regulations that have been given the cover of law, including criminal violations, you have a catastrophe. Strict liability for violating a regulation, some bonehead in a cubicle is put together and the public doesn't even know about. So this is a step in the right direction to correcting the wrongs that government has created, and our government specifically, they just shouldn't be. Work on this began back in 2007, and I want to specifically thank Ed Meese for the role that he played, contacting me at that time as the ranking member on the Crime, Terrorism, Homeland Security subcommittee of this committee, and the work between the Heritage Foundation and the ACLU, as impractical as that might seem, and the work of many organizations, many groups in trying to get something done on these issues. So I'm very grateful to the chairman for bringing this issue to the front. Hope we can do something about regulations that Congress never would have intended to carry prison sentences for violating. Hope we can do something on that. But in the meantime, this is a good start, and I thank those involved in making this happen. Look forward to voting for it. Thank you.
The Chair thanks the gentleman. Thanks the gentleman for his work on the Overcriminalization Task Force as well. Are there any amendments to H.R. 4002? A reporting quorum being present, the question is on the motion to report the bill H.R. 4002 favorably to the House. Those in favor will say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 4001 for purposes of the markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4001 to make technical amendments to Title 18 of the United States Code based on the Law Revision Council's footnotes in that title.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by submitting my opening statement for the record in support of the bill and recognize the gentleman from Colorado, Mr. Buck, to explain his legislation.
Thank you, Mr. Chairman. I'm proud to introduce the Fix the Footnotes Act of 2015. Americans expect our criminal code to be just and fair. The threat of justice is our greatest weapon, a sword, in the war against criminality. But sometimes swords need sharpening, and sometimes our criminal code needs refining. This bill makes technical changes to the criminal code. When Americans' liberty is at stake, each and every detail in federal statutes is important and deserves our utmost attention. For 2 decades, we've gone without a bill like this, so the time is right to fix past mistakes and clean up our ever-growing criminal code. I'm proud that this bill continues the work being done by the Overcriminalization Task Force. This bill will ensure that Congress's intent in the criminal code is clear and that the code is streamlined and appropriately drafted. I urge a yes vote on this bill, and I yield back my time.
The chair thanks the gentleman. Recognize the gentleman from Michigan.
I thank the chair. I support H.R. 4001, and the technical amendments to Title 18 are important, and I would yield to the gentlelady from Texas, Ms. Sheila Jackson Lee.
Mr. Chairman, let me again thank the proponent of this legislation, and I thank him for the Regulatory Reporting Act of 2015, and I add my support to it as it provides for a listing of each rule of that agency whose violation may be punished with criminal penalties. With that, I yield back my time.
And
Sure.
I yield back.
Chair thanks the gentleman and the gentlelady. Are there any amendments to H.R. 4001? A reporting quorum being present, the question is on the motion to report the bill H.R. 4001 favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it. The bill is ordered reported favorably. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 4003 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4003 to require reports and agency rules with criminal penalties for the violation thereof, to evaluate the necessity and prudence of such rules remaining in effect.
Without objection, the bill is considered as read and open for amendment at any point. I'll begin by submitting my opening statement into the record in support of this legislation and recognize the gentlewoman from California, Ms. Walters, for her opening statement regarding her bill.
Thank you, Mr. Chairman. The federal regulatory burden has grown dramatically over the past decades. The discussion regarding federal regulations often revolves around compliance costs and the economic impact. This very committee often plays host to those spirited and engaging debates. Yet, perhaps the most concerning aspect of overregulation occurs when criminal penalties are attached to regulatory violations. Astoundingly, nobody knows exactly how many federal regulations carry the significant penalty of criminal sanction. The vast number of federal regulations and associated criminal penalties renders absurd the statement that ignorance of the law is no excuse. These regulations, with numerous technically complex requirements, pose the formidable punishment of criminal sanctions that hangs like the sword of Damocles above the heads of unassuming good faith actors. It is hard to imagine that even the most diligent individual or meticulous company can be in full compliance with this daunting mandate. Unfortunately, this burden disproportionately impacts individuals and small business that lack the considerable resources to comply. To further complicate matters, many of these criminal penalties are malaprohibita crimes, meaning that they are deemed wrong simply because they are prohibited, as opposed to malice crimes, which constitute morally indefensible conduct. The result being that an unassuming public is subject to criminal punishment for inadvertently and unknowingly violating obscure federal regulations. My bill is an initial step to controlling those criminal penalties, reining in this regulatory overreach, and empowering Congress to reassert its authority over federal criminal law. The Regulatory Reporting Act of 2015 simply requires each federal agency to submit to Congress a report that lists each rule that, if violated, may result in criminal penalties. Furthermore, each agency shall provide justification as to why such criminal penalties are necessary. I want to thank the chairman for his support on this bill. I urge my colleagues to support the Regulatory Reporting Act of 2015, and I yield back the balance of my time.
Chair thanks the gentlewoman. Recognize the gentleman from Michigan for his opening statement.
Thank you, Mr. Chairman. I ask unanimous consent to have my opening statement inserted in the record. I support the measure and yield back the balance of my time.
Thanks to the gentleman. His statement will be made a part of the record. The chair recognizes the gentleman from Texas.
I thank you, and the reason I wish to comment is because I want to make sure that I comment that I was speaking of the H.R. 4003 earlier. So I add my support for the Regulatory Reporting Act of 2015, which would require every federal agency in consultation with the Attorney General to submit a report to the House and Senate Judiciary Committees listing each rule of that agency whose violation may be punished with criminal penalties. It speaks to the broader issue of knowing how much criminalization we are engaged in. So I support that legislation. Let me correct my earlier statement. For the earlier bill, which is H.R. 4001, Fix the Footnotes Act of 2015, and I support that. It's being offered to make technical amendments to Title 18 of the U.S. Code based on the Law Revision Council footnotes in that title. And I certainly support us making sure that we have an efficient system and efficient documents dealing with the criminal code. So I support both H.R. 4003 and H.R. 4001. With that, I yield back my time.
Chair thanks, gentlewoman. Are there any amendments to H.R. 4003? Pursuant. A reporting quorum being present, the question is on the motion to report the bill, H.R. 4003, favorably to the House. Those in favor will say aye.
Aye.
Those opposed, no. The ayes have it. The bill is ordered reported favorably. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 4023 for the purpose of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4023, to eliminate unused sections of the United States Code and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself to submit my opening statement in support of this legislation for the record and recognize the gentleman from Ohio, Mr. Shabbat, for his opening statement on his bill.
Thank you, Mr. Chairman. I'd like to thank you for holding this markup on H.R. 4023, the Clean Up the Code Act of 2015. I also want to thank the co-sponsors of this legislation, yourself, Mr. Chairman, also Ranking Member Conyers, Ranking Member of the Crime Subcommittee, Ms. Jackson Lee, Mr. Forbes, and Mr. Bishop. In 2008, the Heritage Foundation published a report that there were approximately 4,450 federal crimes in the U.S. Code. In 2013, this committee asked the Congressional Research Service to review the code and update this number, only to be told that they lacked the manpower and resources to accomplish that task. When this is the answer given in response to a congressional request, it's pretty clear, it's an indication that there are too many laws out there and the code needs to be cleaned up. Related to the very issue at the heart of my bill, doing away with the unnecessary federal laws, the ABA Journal Daily News published an article entitled "Federal Laws Multiply, Jail Time for Misappropriating Smokey the Bear Image?" Well, thanks to this bill, that will no longer be an issue. H.R. 4023 looks to eliminate 9 provisions within Title 18 of the U.S. Code that in some cases have never once been prosecuted since their enactment. This bill will make an action like misuse of the Smokey the Bear character no longer an offense subject to a criminal penalty. While it may be desirable to prohibit folks from violating certain laws, they should not be subject to criminal penalties for doing so. This bipartisan legislation is aimed at doing exactly what the bill title says, clean up the code. If there were too many laws on the books for the Congressional Research Service to count, with the manpower and resources they have available to them, let's help them out and get rid of the easy ones. And I think the ones in this legislation are the easy ones. With that, I would ask my colleagues to support the legislation and yield back.
Chair thanks the gentleman. Recognize the gentleman from Michigan for his opening statement.
Mr. Chairman and members, I support the measure, compliment my colleague, Mr. Shabbat, and ask that my statement be included in the record, and I yield back the balance of my time.
Chair thanks the gentleman, and without objection, his statement will be made a part of the record. The chair recognizes the gentlewoman from Texas, Ms. Jackson Lee.
Hi, thank you, Mr. Chairman. Let me add my appreciation to Mr. Chabot and the sponsors of this legislation, Clean Up the Code Act. Many of us grew up on Smokey the Bear, and he's certainly a favorite, but I would make the argument that we would hope that that would not be a criminal offense with fines and incarceration, or at least not incarceration, and we think these are important moments. So I want to thank him for the Clean Up the Code Act of 2015 and add my support to it and yield back my time.
The chair thanks the gentlewoman. Are there any amendments to H.R. 4023?
Mr. Chairman.
For the purpose of the gentleman from Texas, seek recognition.
Move to strike the last word.
Gentleman's recognized for 5
I did want to point out after an advertising campaign, it's actually Smokey Bear, not Smokey the Bear, just like it's Easter Bunny and not Easter the Bunny. I just wanted to make sure the record was
If the gentleman
clear
would
on
yield, if the gentleman would yield,
I will yield.
Thank you so very much. However he is called, we loved him. So thank you so very much.
Yep.
Thank you, and I yield back.
And the same would go for Woodsy Owl, I think, too, right? All right. If there are no amendments to H.R. 4023 and a reporting quorum being present, the question is on the motion to report the bill, H.R. 4023, favorably to the House. All those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views.
Thank you for that important clarification.
Pursuant to notice, I now call up H.R. 2830 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2830, to make technical amendments to update statutory references to certain provisions classified to Title II United States Code.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. The Office of the Law Revision Counsel has an ongoing responsibility under Section 285B of Title II of the United States Code to maintain the United States Code and assist the House Judiciary Committee in the revision and codification of federal statutes. In order to maintain and improve the United States Code, the Office of the Law Revision Counsel must occasionally undertake editorial reclassification projects to reorganize areas of the law that have outgrown their original boundaries or to eliminate organizational units that are no longer efficient. The office assures us that the decision to transfer provisions in the United States Code is not undertaken lightly. After careful study, the Law Revision Council recently identified certain organizational deficiencies in the code that need to be corrected and accordingly undertook the necessary changes. As a result, 3 recent editorial reclassification efforts are reflected in the next 3 bills we will mark up today. I'll revise that to say we're going to mark up this first one, and then we'll save the other 2 for our next markup session. So we will not have to return after we recess for lunch. The Office of the Law Revision Council has carefully prepared these reclassification bills and submitted them to the committee for our consideration. The purpose of the first bill we will mark up is to update citations in laws classified to Title II of the United States Code. H.R. 2830 will amend these citations to accurately reflect the new location of the corresponding provisions in the U.S. Code in light of the recent editorial reclassification of Title II. I want to thank Ranking Member Conyers for sponsoring this bill along with me today. Title II of the U.S. Code includes all of the laws governing Congress and the legislative branch. For example, it contains laws pertaining to congressional gifts and travel, representational allowances, the student loan repayment program, compensation of representatives, senators, and staff, and the preference for the purchase of American-made goods. The reorganization of Title II for the purposes of the online version of the code took place on February 1, 2014. Because Chapters 3 and 4 of Title II far outgrew their original boundaries, the Office of Law Revision Counsel reorganized these 2 chapters into 11 new chapters in order to set forth more clearly the provisions relating to the House of Representatives and the Senate. No statutory text was altered by the reorganization. The provisions were merely transferred from one place in Title II to another. As a result of the reclassification, Title II now better exhibits the laws governing congressional pay and benefits, ethics, leadership and administration, just to name a few. It is important to note that the Law Revision Council advises us that the short-term inconvenience of adjusting to new code citations is greatly outweighed by the benefit of much-needed long-term improvements in the organizational structure of the United States Code. Further, to eliminate any confusion, the office provides a comprehensive guide to the old and new code citations on its website, uscode.house.gov. With the enactment of this legislation, the citations in our public laws that refer to code sections altered by the reorganization will be updated to reflect the changes made to Title II. For the foregoing reasons, I urge my colleagues to support this important bill, and I'm pleased to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Mr. Chairman, I thank you. I commend you for making this reclassification, which makes the law clearer, and I ask unanimous consent to have my statement and made a part of the record, and I yield back the balance of my time.
Thank you, Mr. Conyers, and without objection, your entire opening statement will be made a part of the record. Are there any amendments to H.R. 2830? A reporting quorum being present, the question is on the motion to report the bill 2830 favorably to the House. Those in favor will say aye.
Aye.
Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views, and we will save the 2 remaining bills on the agenda for our next markup, which we anticipate will be the week after Thanksgiving. And I want to thank all of the members of the committee for their participation in these important bills that we've marked up today. And with that,
Mr. Chairman.
Chairman, the gentleman from Texas seek recognition.
Well, I think it is appropriate for the years of service that Mr. Conyers has given and the collaboration that both of you have had, and I've been privileged to join you with Mr. Sensenbrenner to say this was truly a historic day. It is not often that we spend a period of time on criminal justice laws. As much as this committee has such a broad jurisdiction and so many responsibilities, I think we have commended ourselves, meaning Republicans and Democrats, on a committee that in many instances may have disagreements, rightly so, that we can say that the criminal justice system, as long as its history has been, it is one of the oldest aspects of justice, is that criminal code, to say that we've been able to confront it in a positive way to be able to improve the lives of Americans. So I want to thank everybody on the committee, and I think this was a very, very special day in the history of the Judiciary Committee.
Would the gentlewoman yield?
I'd be happy to yield to the gentleman.
thank the gentlewoman. She makes a very good point, and I appreciate her leadership on this issue, and I thank her for recognizing the ranking member of the committee who has worked long and hard on this committee, and I know how important criminal justice reform issues are to him, and I commit to both of you and to all the members of the committee that we're not done with this, that we have more bills to do in prison reform, in policing strategies, in juvenile justice, and other areas that I know the gentlewoman and others on the committee are very interested in, and we are going to move ahead with all due speed to bring those forward to the committee and mark them up and get them to the floor of the House as well. We have a great opportunity here, and we should not squander it. So I thank all the members of the committee for their participation today. And with that, the committee will stand. The gentleman from Michigan is recognized.
Mr. Chairman, and to the gentlelady from Texas, I want to thank both of you and a number of other members on this committee for expediting, improving, and making more available the clear meaning of the important judiciary legal decisions that are made in the Committee on the Judiciary. I thank all of you and yield back the balance of my time.
Thank you.
This concludes our business for today. Thanks to all our members for attending. The markup is adjourned.